Hi, my name is Hyderally. I'm a plaintiff's lawyer with offices in Montclair, New Jersey, and we practice in New Jersey and New York and concentrate in employment law. So we're at a very unique crossroads in the history of our country. And of course, I speak nationally as well as, of course, in New Jersey and even in Montclair. With regard to incidences of employees who are engaging in free speech outside of the workplace and then have some consequences within the workplace. For example, we have situations such as people have presumably heard of Amy Cooper, right? Amy Cooper is a Caucasian woman who was in Central Park and made a complaint that an African-American man was threatening her when her dog was, when he simply asked her to leash her dog. And she filed a complaint with the police department after being verbally abusive to this man who was doing nothing wrong. Amy Cooper was subsequently terminated by her employer, Franklin Templeton. There was also an incident of a shopper who was at a Costco in Fort Myers, Florida, who recently yelled and cursed at another shopper in the store and then was subsequently terminated by his employer, Ted Todd Insurance. So we have these situations of people who engage in conduct outside of the workplace and are subsequently either disciplined or terminated within the workplace. And they ask the question, well, how can this be? How can we be terminated for engaging in what they consider to be free speech outside of the workplace? And the answer is, unfortunately for those employees, and possibly depending on your moral compass, fortunately for the employer, that person can be terminated. And the reason is because when you work in a private employment workspace where it's non-union, you have no employment contract, you're an at-will employee in the state of New Jersey. And what that means is there is no right to free speech, to constitutional rights to free speech outside of the workplace within the workplace. So if an employer terminates or disciplines you because you threatened or cursed out another person outside of the workplace, that is not considered an illegal employment action. Now, of course, if the employer's action is tainted because of your gender, your race, your disability status, that's a different situation. That is a violation of the law. New Jersey has a very vibrant statute called the Law Against Discrimination, which protects employees from that type of action by the employer. Or if an employee complains that the employer is engaging in acts of discrimination or sexual harassment, and then that employee is subsequently terminated, that employee has some substantive rights under the retaliation component of the New Jersey Law Against Discrimination, 10:5-1D. Additionally, if the employee complains that, for example, if there is an order, an executive order requiring employees to wear face masks in the workplace, and the employer is saying to employees, no, I don't want you to follow that executive order, I don't want you to wear face masks in the workplace, and that employee complains about that, what would in essence be an illegal request by the employer, and that employer then terminates that employee has rights under a statute called the Conscientious Employee Protection Act. It's a whistleblower statute. So there are certainly protections in the workplace, but at the end of the day, employees would be well served to remember, you engage in abusive behavior outside of the workplace, you can be terminated within the workplace. This is Hyderally. We have offices in Montclair, New York, and we practice and concentrate in the area of employment law. Be safe and be well.